a global courtroom for investors. Introducing the ICSID. The International Centre for Settlement of Investment Disputes, or ICSID, is a global institution. It helps resolve disputes between foreign investors and host states. Established in 1966, it aims to promote stable and predictable investment environments. ICSID is part of the World Bank Group, headquartered in Washington, D.C. ICSID plays a crucial role in international investment law. It provides a neutral and depoliticized forum for dispute settlement. The ICSID Convention, its founding treaty, has over 160 signatory countries. This reflects the widespread global acceptance of ICSID's role in facilitating peaceful resolution. The ICSID Secretariat, its administrative body, assists with case administration and provides resources for parties involved. Does your dispute qualify? Understanding ICSID's jurisdiction. ICSID's jurisdiction is founded on the consent of both the investor and the host state. This consent is typically expressed through investment agreements or national laws. For ICSID to hear a case, specific requirements must be met. First, the dispute must arise directly from an investment. Second, it must be a legal dispute involving issues of rights and obligations. Third, the dispute must be between an investor of one ICSID member state and another ICSID member state. ICSID's jurisdiction is limited to disputes that satisfy these criteria. It underscores the importance of clear and comprehensive investment agreements. Fair play guaranteed. The ICSID arbitration process. ICSID arbitration is designed to be neutral, independent, and efficient. It offers a streamlined alternative to traditional court proceedings. The process begins when an investor files a request for arbitration with ICSID. Both parties then appoint arbitrators to form a tribunal. This tribunal considers written submissions, evidence, and legal arguments from both sides. Hearings provide an opportunity for parties to present their cases directly. The tribunal then renders a final and binding award based on international law and the terms of the relevant investment agreement. Section 4. Why ICSID? Benefits for investors and states. ICSID offers several advantages for resolving investment disputes. For investors, it provides a forum for impartial adjudication. This is particularly valuable when operating in jurisdictions where the local legal system may be unfamiliar or perceived as biased. ICSID awards are enforceable in most countries. This greatly enhances the likelihood of successful enforcement. For states, ICSID offers a mechanism for attracting foreign investment. By committing to ICSID arbitration, states signal their commitment to fair and transparent dispute resolution. Section 5. Modernizing justice. Recent updates to ICSID arbitration rules. ICSID periodically updates its rules to reflect evolving needs and best practices in international arbitration. Recent amendments, adopted in 2022, introduced several significant changes. These include provisions for expedited proceedings in smaller cases, enhanced transparency, and greater party autonomy. The amendments aim to make ICSID arbitration more efficient, accessible, and cost-effective. Notably, they provide greater clarity on third-party funding. This addresses concerns about potential conflicts of interest and ensures transparency in the financing of arbitral proceedings. Section 6. ICSID's impact, fostering a stable global investment climate. ICSID plays a vital role in promoting a stable and predictable global investment climate. By providing a neutral and effective mechanism for resolving disputes, it enhances investor confidence. This, in turn, encourages cross-border investment flows and contributes to economic development. ICSID's commitment to fairness, transparency, and efficiency has made it the preferred forum for settling investor-state disputes. As the global economy becomes increasingly interconnected, ICSID's role is only set to grow in importance. Its ongoing efforts to modernize its rules and adapt to changing needs demonstrate its commitment to remaining at the forefront of international investment dispute resolution. Section 7. ICSID and Nepal, a strategic partnership for investment. ICSID rules of arbitration hold significant relevance for Nepal, as the country is a signatory to the ICSID Convention and has incorporated provisions for investor-state dispute settlement in its bilateral investment treaties, or BITs, and other investment-related agreements. This enables both foreign investors in Nepal and Nepali investors abroad to use ICSID as a forum for resolving investment disputes. Key points on the relationship between ICSID and Nepal. Pause 1s. First, ICSID membership. Nepal signed the ICSID Convention in 1965 and became a member in 1969. This means that Nepal recognizes ICSID as a forum for resolving investment disputes involving foreign investors. As a member state, Nepal is obligated to enforce ICSID arbitration awards without needing to subject them to local court review, giving investors confidence in the enforceability of awards. Second, bilateral investment treaties, or BITs. Nepal has signed several BITs with other countries that often include ICSID arbitration as a dispute resolution mechanism. These BITs offer protection to foreign investors by ensuring that disputes between them and the Nepali government can be resolved through ICSID arbitration. For example, Nepal's BITs with countries like Germany, France, and the United Kingdom include provisions that allow investors to bring disputes to ICSID arbitration, thus promoting foreign direct investment by offering a neutral international forum for resolving disputes. Third, relevance for foreign investors. ICSID provides foreign investors in Nepal with a neutral forum to resolve disputes that may arise with the Nepali government, avoiding potential biases that could be present in domestic courts. It also gives investors a layer of protection against political risks such as expropriation or changes in regulatory frameworks that might negatively affect their investments in Nepal. Fourth, use of ICSID arbitration in practice. While Nepal has not faced many ICSID cases, there have been instances where investors have invoked the ICSID framework to resolve disputes with the Nepali government, particularly in the hydropower and infrastructure sectors, where large foreign investments are often involved. Disputes under ICSID are handled in line with the ICSID arbitration rules, which guarantee a fair and transparent process for both investors and the state. Fifth, enforceability of ICSID awards in Nepal. As a signatory of the ICSID Convention, Nepal is bound to enforce ICSID awards. If an ICSID tribunal issues an award in favor of a foreign investor, Nepal is legally obligated to comply with that decision and cannot challenge it through domestic courts. This enforceability provides greater legal certainty to investors, making Nepal a more attractive destination for foreign investment. Sixth, role in promoting foreign investment. The availability of ICSID arbitration as a dispute resolution mechanism helps boost investor confidence. Investors are more likely to invest in Nepal if they know they have recourse to a neutral and internationally recognized dispute resolution forum in case of any issues with the government. This aligns with Nepal's broader goals of attracting foreign direct investment, particularly in sectors such as hydropower, tourism, and infrastructure. Seventh, challenges and considerations for Nepal. Although ICSID arbitration is beneficial for attracting foreign investment, the government of Nepal must balance investor protection with its own sovereign rights. ICSID arbitration cases can be costly for developing countries, and unfavorable rulings can result in significant financial liabilities. Nepal needs to ensure that it implements clear, transparent and stable regulations for foreign investments to minimize disputes that could lead to arbitration. In conclusion, the ICSID rules of arbitration are highly relevant to Nepal as a signatory of the ICSID Convention. ICSID provides foreign investors in Nepal with a neutral and enforceable mechanism for resolving disputes, thus contributing to investor confidence and the country's efforts to attract foreign investment. However, Nepal must also carefully manage its obligations under ICSID and ensure that it maintains a stable and investment-friendly legal framework to avoid costly disputes. Thank you for watching. Don't forget to like, share and subscribe for more insights into international investment and arbitration.